Hello, everyone. My name is Raul Cuevas, and today I'm going to break down some important things people may not know when it comes to search and seizures and some common misconceptions. This next slide kind of just goes over some of the things that the Fourth Amendment protects. So basically, the Fourth Amendment protects people from unreasonable seizures and gives rules to police and some of the rules that they have to follow, like needing probable cause and often a warrant signed by a judge. It also protects our privacy, especially in our home, and limits government power from being abused. One of the things that people don't really know about is that there are exceptions to the Fourth Amendment. So people believe that police always need a warrant. That is not true. The law allows certain exceptions where we can search legally without one. People believe a probable cause just means a guess or suspicion. That's also wrong. It's based on facts, evidence, and what we can articulate based on our training and experience. If we believe someone inside is about to destroy evidence or someone is in danger, we can go in immediately based on exigent circumstances. In real life, we don't always have the time to call a judge. So if there's an emergency, the law allows us to act immediately. Another thing most people don't realize is how many legal exceptions exist when it comes to searching people and vehicles. For example, there's case laws that state the following things. For example, there's Terry versus Ohio, which it allows police officers to stop and frisk people having reasonable suspicion, and you don't need probable cause to do that. And it's limited pat down search for weapons, so you could just pat them down, make sure that they don't have any weapons on them. Then there's also Michigan versus Long, which that one states officers can search first the passenger area of a vehicle if they have reasonable suspicion that the suspect is dangerous and the suspect may gain immediate access of weapons inside the car. This applies sort of like whenever you stop like a known gang member or somebody that has been arrested before for being in possession of weapons when they shouldn't have access to any weapons, and you believe there might be in possession of a weapon and it might be inside the vehicle. There's also Carroll versus United States, which I listed there, Arizona versus Grant. And another thing people don't realize is that consent to search, which is like, say the person driving the car gives you voluntary consent to and allows you to search the car, then obviously at that point you don't need a warrant to search it because they're allowing you to do